actors' stories, why Naga Chaitanya divorced, who is that? Samantha, nothing will happen to us. Correct? Whether they divorced, neither she comes nor he comes to us. Don't worry. See, our Supreme Court advocates, right, they have YouTubes. They are giving webinars, excellent topics they are presenting. Nicely put earphones and listen that. You will enjoy the subjects. Just a clue. Okay, let me come to the point. 12 years, generally what we will do now, for example, Krishna Prasad is selling to me. First I have to ask, and as an advocate, my advocate will ask him, Krishna Prasad, how you are a owner? Sir, I purchased 2 years back from Jalaja madam. Oh, Jalaja madam, how you are the owner? Sir, I purchased from Mallikarjun sir. Oh, when? Just 4 years back. 4 plus 2, 6 years only. Still I have to go back. Mallikarjun sir, where you purchased? Sir, I purchased from Justice Kumarayya so and so society. When, sir? That is around 20 years back. Puro. So, Mallikarjun sir sold to Jalaja madam. Jalaja madam entered an agreement with some other professor. So, these are all known as linked documents. Why we need 12 years we have to see linked documents who are the owners and whether title is clear or not. That is the importance of the recital. How and simply Srinivasa Rao says that, sir, I purchased property from him, sir, last year. Last year you purchased from whom? From so and so. How that fellow knows, sir? I don't know. Baba, call him. Baba, whether he may be trespasser. You understood? He may be a trespasser. Correct or not? So, that's why we need 12 years linked documents. Number 2, one more important. Recently one of my friend told me, when I am purchasing, whether that fellow has taken any loans, any encumbrances, any mortgages are there, we have to know that. From whom you purchased. This is the linked documents. That's the purpose. That is a brief history of the document. Please remember, not simply drafting a document, somebody comes, sir, I am selling, you note down, I am purchasing, note down means, nah. Yes, today one of my friend told me, one of our senior advocate, legal advice, that is, my property is valid property, I can take a loan. If I go to a senior advocate, he will take a minimum 1 week. What he will do now? Go, bring the documents. From where you purchased, bring the documents. Why? Your title will be perfect tomorrow. Your ownership will be perfect tomorrow. Otherwise, what this advocate is harassing me, this document, that document. Arey Baba, fool, that is for your purpose only. If you bring all the documents, there is no any problem, you have a good title. Your title is not having any problems. People will think, I will give 1,000 rupees. Give Re Baba, within half an hour I will wait outside. What to give? Make it boat, put in Maner Dam. That legal opinion. What is the use? Learn as an advocate what we have to do it. What is the responsibility of an advocate? That is the point. See. Narrative. Trace the title of the transferor. When I am selling, how I have a title. Mode in which he acquired. How I got the property. From my father, succession, or I purchased it from somebody, or some government, because I am a poor fellow, government granted me something. How you acquired? That is the meaning. Right. Whereas the owner becomes so and so, he purchased the property from so and so date, everything. You can see that. I will give to your professor, your in charge, then he will take your director's job. Right? See, events subsequent to the transfer or acquiring the title or ownership of property. Okay, simple. They will write, I purchased the property, I am the owner, but now recently I gave to Satya sir as a tenant, now he is in lease agreement. Right? Lease agreement, write in that. So, everything you have to write about the recital. That is the meaning. After you purchased the property, what happened? Yes. Introductory recital. Why you are selling? Why you are very simple. Whereas the vendor, for the purpose of his financial need, to perform the marriage of his daughter, morning I asked you same thing. Because Why? See, one unsound mind fellow, when he sold it, the question is why he sold? Because Indian Contract Act, those who studied undue influence, misrepresentation, mistake, fraud. You remember? Contracts are not valid, either void or voidable. Correct or not? To avoid that, to say that out of free consent, because of my daughter's marriage, I sold, means free consent. Freely, because of my necessity, I sold. That is the purpose you have to write. That is the meaning of that. Simple. Clarify, transferor, the title of the transferor, and right? And one need not refer previous document. Once it is clear, everything in the sale deed you clearly mention. Srinivasa Rao is the owner of the property because he has purchased the property from Satyaya sir in the year so and so. Wide registered sale deed number so and so. Means by seeing that, oh, Srinivasa Rao sir purchased from Satyaya sir in 2000. No problem, 21 years over. No need to go beyond Satyaya sir. Enough Satyaya sir. Because already 20 years over. 12 years puro. 12 years enough. In Konkani puro means enough. Okay. Right. So, it also discloses the motive why Professor Srinivasa Rao is selling the property. Right? This is the actual meaning, my dear friends. Thank you. Now, last part, most important other side. With this, your documents are over. Then I will show the pro formas. Testatum. In this, and this is operative part. Consideration. What is the amount? Gift, there is no love and natural love and affection. Sale, what is the consideration? How much purpose you are selling? Receipt, listen. Simple question I will ask you, give me fastly answer. When I am selling the property to you, all of you listen. When I am selling the property to you, 40 lakhs I am selling. You gave 40 lakhs, I gave sale deed. My question is whether for the 40 lakhs I have to give a separate receipt, or in the sale deed only, Srinivasa Rao writing that I transferred my property to one of my student for the valuable consideration of 40 lakhs rupees, which was received. I hereby receipt acknowledged. I am acknowledging the receipt. In the sale deed only we are writing, or otherwise one more, like in Dukan, in our shop, we are giving 40 lakhs received. Take. One more we are giving. Tell me, sale deed only we are writing or separately giving receipt? Sale deed only we are writing. That is correct. That is the receipt. No separate receipt. Right? Gita Bhavan receipt. Now, right. Operative words. I will show you within few minutes all these things fastly. Because if you can see it fastly, you will understand. Now this deed of sale, first all 4 points are over. This deed of sale heading over, date over, parties over, how I got the property, why I am selling, recitals over. First all 4 over. After all 4 over, next heading is this. Now this deed of sale witnesses as under, heading, etc. Like that. Then starting the sale deed, starting the lease deed, gift deed, whatever may be the deed. First those 4 common. Non-operative part, that is, operative part now starts. Because why non-operative? Nothing to operate there, only informing sale deed, date, parties, why they are selling, how that fellow became an owner. Actual selling started now. Correct or not? Actual selling started now. That is what? Testatum. Yes, this is the word. The meaning is this one. Right? I am hereby mentioning. Consideration. Why consideration? Morning your chief guest told stamp duty. How much we have to pay register office? What is the value of the property? Most of you know very well. Market value something, black market rate something, in between something, something. Government something. I hope you understood. No need to more than that. So this is the stamp duty purpose. Correct? For what value you are purchasing, mention it. That is the purpose. For ascertaining the stamp duty. If it is 40 lakhs, 30 lakhs, 20 lakhs, 50 lakhs, whatever it may be, accordingly how much stamp duty we have to pay. That's why consideration is important. Operative part. Right. Receipt. Acknowledgement. I will show you. Now this deed of witness that in pursuance of the aforesaid agreement in consideration of 50 rupees or 50,000 or 50 lakhs paid by purchaser to the vendor, the receipt of which the vendor here acknowledge. That is the line. That is the one line you are writing. Means that fellow paid money, our fellow received. Buyer paid the money, vendor received the money. That is the receipt. Operative words. What is operative? Hereby grant, vendor. Hereby grant, convey, sell, some words. Not in all will not be there in every agreement. Depends on what type of agreement. It is a sale deed, it is an agreement to sell, it is a lease deed. Depends on that they will write this word. That is known as operative words. I will show you everything in one document within few minutes. Parcels means description. Where your property is there? What property? House? Yes sir. Land? Yes sir. Which one you are selling? Parcels. Property situated in Mukarampura, so and so survey number or so and so flat number in so and so apartment. Parcel. Full details you are writing in schedule. After entire sale deed over, lastly schedule will be there. What is the schedule? Property situated in Mukarampura, square meter so and so something, south, east, west, north, boundaries. That is the schedule. Schedule is in details of the parcel. Please remember, words only new, concept is simple. When I am selling, what I am selling to write? No, I am selling house, I am selling land, right? That is the parcels. Clear, my dear friends? Parcel meaning property. What property you are transferring? Right? Come on. See, whereas mortgagors are, being the owner of a property named Shanti so and so, right? More fully described in schedule therein. This is parcel where your property is situated, fully described in schedule, last para. That I will see later. That is the meaning. You are writing like that. In your sale deed, you are writing like that. In your mortgage deed, you are writing like that. You are mentioning like that. First, briefly, you are mentioning. In detail, if you want to know, see my schedule. Schedule means once entire sale deed is over, lastly we are writing. I will show you within 2 minutes. Right. They will write coloring and all those they will do by colored or colored boundaries. Boundaries also they will, in the map, they will put map also. Along with the map, this share I am selling. This share, because remaining belongs to my father or belongs to my mother or belongs to my brothers. Only out of this share belongs to me. I am coloring that. Some of you understood? That is the meaning. Exceptions and reservations, very rare. Not every agreement may not be there. Almost over. Within few minutes I am completing. Exceptions and reservations means I am selling except so and so I am not giving. I will show you within few minutes. Yeah. I am mortgaging my factory except a particular machinery. That machinery I am not mortgaging. Remaining all machineries I am mortgaging except so and so. In case if you want to mortgage like that, write except. What is reserve? Reserving means I am giving for rent purpose first floor, reserving my right to go to the second floor via the staircase. Reserving with me the right to go to the second floor. First floor I am giving rent to you. Second floor to go to, I am reserving a right. That is reserving. Clear? Exception, reservations. This depends on case to case. May not be there in every agreement. May not be there in every sale deed. May not be there in every mortgage deed. Depends on parties to parties and agreement to agreement, my dear friends. There may be a chance. Clear? Exceptions and reservations. This is not compulsory, but most of the advocates are writing as a common pro forma. To have and to hold, to use the purchaser. These are not compulsory words, but most of the sale deeds, if you see in pro forma, it will be there. But not necessary, you do it or not do it. Most important, covenant. Listen first. Means I am agreeing. I will tell you a simple way, you will easily understand. When I am selling the property, there are 4 important covenants will be there. Yes. Last bench, please. I have weakness, my dear friend. When I am talking, I don't allow others to talk. Weakness, don't feel anything. Right. There are four, every agreement, different covenants will be there. Covenant means an agreement with an obligation or an agreement with a party. I will tell you a simple example. You will easily understand first. You are giving your house to me rent purpose. One condition you made. Srinivasa Rao, don't make any alterations or don't make everywhere nails, because Hindus know so many gods from Ayyappa to Lord Venkateswara, full gods are there. My wall becomes only holes only. I hope you understood. Maximum you pray only one God, remaining gods inside you pray. How many understood? My owner putting a condition to me. Covenant. Prof. Srinivasa Rao, don't give for sublease. Means I am giving a big bungalow, don't give one more room for some other person without my permission. How many understood? Don't give for sublease. Covenant. Clear? Most important things. I will tell you sale lead. There are four important. I will show you within few minutes. Actually, to be frank, I will tell you, being a law student, you can understand, implied covenant, express covenant, there are two types. Implied covenant means even you are not mentioning also, according to law, it is there. Try to understand. Technical word, not difficult word. Very simple. I will ask you one simple question, you will give me answer. When I am selling the property, what is implied covenant? I will give an example. Whether it is implied covenant or not, you tell me. When I am selling the property to you, is it not an implied covenant? I am the owner of a property? Come on. I am repeating. When I am selling the property to you, is it not an implied covenant that I am the owner of a property? Or I have to mention, yes, I am the owner, I am selling. I am the owner, I am selling. I have to mention? Anyway, recital you are telling how you are a owner, enough. No need to, so much you have to mention. Nobody is having any right or something, nah. But most of our people, including our advocates, of course, I am not blaming, it is a true precautionary measure they are writing. Srinivasa Rao is an absolute owner of the property, right? Covenant number one, about my title. Number two, Srinivasa Rao allowing the purchaser to peacefully enjoy the property. Neither Srinivasa Rao nor his family members will disturb the purchaser. We will allow you to covenant for peaceful enjoyment. Covenant for peaceful enjoyment. Because you purchased the property, you peacefully enjoy. Tomorrow my wife or my daughter or my brother or my sister, anybody disturb you, I will be responsible. I am indemnifying you. I will take care about you. I will see that whatever the loss caused to you, I will stop them and I will save you from the loss. Indemnity. I am indemnifying you. That is known as covenant for peaceful enjoyment. First one is covenant for title. Second one is covenant for peaceful enjoyment. Third one is covenant for nil encumbrances. Nil encumbrance. How many of you heard? Raise your hands. Very good. When you go to the bank loan, they will ask, go and bring nil encumbrance from your revenue office. Means on your land you have not taken any other loans. On your land your brother or sister or nobody is having any right over the property. Nil encumbrance means there are no any restrictions or no obstructions or no what we can call it as encumbrance means there is no any obstructions for your property, your title. You don't have any loans on the property. Nobody have any right over the property. Only you have a right. Your sister also not having any right, like that. That is known as a nil encumbrance. Clear? Last one. So three covenants I told you. See, please remember, this is in sale deed. Covenant for a title, covenant for thank you, peaceful enjoyment, covenant for nil encumbrance, last one, covenant for future assurance. What is that? I'll tell you. Covenant for future assurance. Future assurance means tomorrow you want to construct on the land. Our municipality, they will ask, this form has to be signed. You want to sign. Your owner, municipality fellow told, no, not you. Who sold you? Srinivasa Rao. take his signature. Why? We want to know he also saying that I have no objection, I sold to so and so my student, I have no objection, he can construct. Municipality people are asking. Means what I am telling, tomorrow if any time you need any signature of mine, I will assure you, I will come and sign, but you give my food and some TADA. How many understood? What is a future assurance? I am repeating, listen. Those who are sleeping, please get up. What is a future assurance? Future assurance means tomorrow, if any time my necessary comes to you, why it will come? Because you purchased it. Why it comes, Srinivasa Rao sir? Because tomorrow when you want to take a permission from town planning country something, they may say that who sold to you? Srinivasa Rao. Take no objection from him also. Then that fellow will come. Srinivasa Rao sir, sign. Means what I am telling, don't worry. In future, any time my signature required, anything my help required, I will assure you, I will come and help you. These are the 4 covenants. How many understood? Thank you. That is the covenant. Covenant of title, covenant for peaceful enjoyment, covenant for nil encumbrance, covenant for future assurance. In a sale deed. In a sale deed. Clear? Because depends on different deeds, different covenants will be there. I told you, in a lease agreement, don't give for sublease. Don't make any alterations without my permission. Don't take water connection without my permission. Don't take so and so things without my permission. Because I gave only lease purpose. I gave only rent purpose. Covenants. Right? Okay. Last one. Schedule. I told you. Boundaries. East, west, south, north. Correct or not? Your property boundary, specifically, clearly your money. Parcel is about your property. Description of a property is a parcel. Right? In detail about the property is a schedule. See the words, how it is. All that property, so and so, situated so and so, east, west, something. That is the way, my dear friends, how we are writing the point. Last one. Last, almost we reached. In witness, that is a testimonium. Whereas parties here means purchaser, seller, mostly seller in a sale deed, signed by this at the place of Karimnagar, so and so date, signature I will show you. Like this para they will write. That is known as testimonium. This is only legal terminology. Indeed, we won't write. We are writing only this one only. We are writing only this. We won't write within brackets testimonium. We won't write. As a legal students or law students, we are knowing what is the name side heading. But we are not heading, description, directly this deed. Correct or not? Right. This is known as, please remember, execution clause. Last one. Everything over. Sale deed executed. Lease deed executed. Means this deed was read over, means I am a seller. I read over, explained to me, because if I am an illiterate, I am writing this word, then two witnesses. Generally, I will tell you, my dear friends, legally, gift and mortgage has to be attested. All of you remember, please note down. Legally, gift and mortgage only, attestation required. Attestation means witnesses. 2 witnesses. Sale deed and all those not necessary. Precautionary, we are taking signatures. Legally, only mortgage and gift only compulsorily has to be attested. But in all documents, executants means mortgage or mortgagee, seller or buyer, lessor or lessee, and witnesses. Lastly, that is execution clause. I will ask a simple question. Fastly give me answer because we have to see the pro formas. First question. Is it necessary? Witness has to read the document before he is signing. How many of you are saying yes? Raise your hands. Okay. Now, second question. I will not give answer. You only will give answer. Is it necessary? Witness has to be literate. Acha. When it is no, how he will read? Number 2. I hope you got the answer. One more question relating to that only. Within 2 minutes I will complete it. Because if it is there, it's making so much sound. Very simple question. Witness is, listen carefully. Witness is witness for only signature of the parties. Point number 1. All of you listen carefully. Your advocate Saab, he is selling to Madam Jalaja. Myself and Satyaya sir are witnesses. What we both of us understand is, we are only witnesses of his signature and Madam's signature. These two people are saying, Srinivasa Rao, Satyaya sir, both of you are not reading the document. We don't have that much time. I have to go by flight. Sir has to go to his some place, his workplace. We told him, no, we don't want to read. Over. Document over. We both of us seen. He signed. Madam signed. We went. After 6 months, there is a problem. Whether this sale is valid, this gentleman saying that I didn't sign. Or this is not a mortgage, something he is challenging. Some dispute between them. They called me. Once again, I came from Goa. Sir also came, Satyaya sir. We both attended the court. One box is there, we attended. I tell the truth, nothing but truth, everything truth. Something I will tell, something over. I promised. Everybody will say, whether it is truth or lie, he will say that. Advocate asked, Srinivasa Rao sir, do you know there is an agreement between Venugopal Rao sir and Ma'am Jalaja madam? Agreement, sir? Agreement means what, sir? And there is some transaction has taken place, you are a witness. I am a witness. Yes, sir, I am a witness. What is the transaction between them? I don't know. Then what do you know? He signed, Madam signed, I saw. Note down, Your Honor, this is the Srinivasa Rao sir witness. Satyaya sir, what you did? Srinivasa Rao sir, what he did, I also did same thing. Now both the Venugopal Rao sir advocate started argument. Your Honor, is this a witness? Jalaja Madam sir advocate raised it. Your Honor, witness means witness for the signature of only the parties. They need not bother what is the transaction inside. That is their problem. Why these people problem? Why then what is the value of witness? They will say, both of them voluntarily entered agreement. We saw that, sir, their signatures only. Why they signed? That is their problem. They have to read because they are signing, their problem, they are purchasing, they are selling, they have to read. Why we will read? If that is the case, nobody will be witness. Maka, I don't want. Correct. Or now tell me, still witness has to read the entire document. How many of you are saying still witness has to read the document? Achha. He has to read the document, madam? Okay. But all other people are not raising hand, no? They are all against us. We'll see. Yes, my dear friends. Last question. Witness are only witness for signatures or for document? Come on. Only for signatures or for document? How many of you are saying only for signatures? Signatures of a document. Please try to understand. Signatures means not on the wall. Document means whether it is a mortgage deed, whether it is a leave and license, whether it is a lease agreement. Arey Baba, I don't know all those things. I am the witness that I have seen before me, they signed. Tell me now, how many of you are saying a signature, witness for only signatures? Come on. Answer is, now I am giving answer, otherwise my flight time comes. Answer is very simple. Witnesses are only witnesses for signatures of the parties. They need not bother about what they have written inside. Why I am bother? He is signing, he is responsible, she is signing, she is responsible. Then what is your? I am telling they signed. Tomorrow they cannot say, that is not my signature. Otherwise, who will come witness? You wrote for 20 pages and I am not selling, I am not purchasing. Why I will read? I have already problem with my wife. Why this problem? Right, okay. Okay, my dear friends, remember that is the witness meaning. Any doubts on this? Remember all of you. Sale deed has to be registered. more than 100 rupees value. Lease deed has to be registered. Come on. I gave a blank, 1 minute only. Fastly tell me, any one of you, if you know the correctly. Two options. Lease deed has to be registered if it is more than 100 rupees, option A. If it is more than 11 months, option B. Which one is correct? Or both? More than 11 months. More than 11 months. More than 11 months, not more than 100 rupees. Or both? Or both? Gadabada fellow. Why unnecessarily both you told Srinivasa Rao sir? You can give two options and you can stop it. Ne? Too much you ate, I think. So much you are talking. Options only two give, don't give three. Answer is excellent. Only more than 11 months. 100 rupees rule does not apply for lease. Whatever it may be the value of the property, lease registration required depends on the duration, not on the money. Money only mortgage and sale. Mortgage and sale only depends on the value of the property. Registration is important. Please remember, each and every word is important. Right? I am not telling about Goa is like this, beaches are very good. No, that I will tell later. Clear? Remember. So, lease more than 11 months. Registration compulsory according to section 107 of Transfer of Property Act. Finally, when I sold, delivery of the deeds, my sale deed, I purchased it from Venugopal Rao sir, linked document. I am preparing a sale deed in favor of Jalaja madam, that one. Linked document, my document. Two sale deeds I am giving. Last few years onwards I am paying municipal tax, bills I am giving. Whatever the relevant documents, delivery. House sale completing. Friends, that is the way how to write a deed. Now we are seeing a few minutes, one pro forma of a sale deed, one pro forma of an agreement to sell. Then we will enter into lease and license and mortgage.